welcome to our May 16th program sponsored by the League of Women Voters Grand Traverse Area in partnership with Traverse Area District Library, which hosts us in its wonderful location with the Traverse Area Community Media, which offers technology and media support. Our topic today is the First Amendment and the Supreme Court. I am League member Eunice Crockett and your moderator for today's program. The League of Women Voters is a national nonpartisan organization. The League does not endorse nor oppose candidates or political parties, but does work to obtain and distribute information to the public about candidates and their views. The League promotes the informed and active participation of all citizens in government. It works to increase the understanding of major public policy issues through education and advocacy. Membership in the League is open to women and men of all ages and offers a special discount for students. Our program today is being shown on channel 189 with Spectrum Cable in Northwest Lower Michigan, on the League of Women Voters Grand Traverse Area Facebook page, and on Tattle, our wonderful Traverse Area Library YouTube, and of course here in person at our studio audience. Today we welcome Eleanor Lynn. She began her legal career at the Iowa College of Law, where she worked intensively on constitutional law and Native American law publications. She received her Juris Doctorate degree with distinction from the University of Iowa College of Law. She has worked in various areas of law, including constitutional litigation and Native American law, served as Assistant Attorney General of the Iowa Department of Justice, and has been an adjunct professor of law at Cooley Law School. During the last part of her career in private practice, she specialized in medical malpractice defense litigation. She now teaches NMC, our local college, classes on the First Amendment, and there are probably things in there that I didn't mention, which she has done. Our program today will focus on the Supreme Court and how those decisions affect us. It's an immense topic. She will be willing to stay even after our questions. We have a timeline on wrapping it up here, but she will stay after if there are more questions or discussions. Let's welcome Eleanor Lynn.
Thank you very much. She made me sound a lot more qualified than I am, trust me. And I teach extended education in the First Amendment arena. I'm not on the actual faculty. I haven't even tried to be. But I did just finish the First Amendment class, and we actually had 10 hours of instruction time. I see a few of my students and former students here. Thank you for coming. And they will tell you that in 10 hours of class time, we really didn't get everything done we wanted to do on First Amendment issues. So today, the only reason you might say, well, I thought we were here to talk more about the Supreme Court. Why do we have to talk at all about the First Amendment? And the quick answer would be we probably don't. But is it important other than the fact that I like the First Amendment? Well, I think it is, and I think the reason it's important to a discussion of this particular Supreme Court, the Roberts Court, which thinks it's getting a very bad rap right now, it has been accused of weaponizing the First Amendment for certain purposes of advancing a certain agenda. So we're here today to examine, is there any credence to that? Is there any legitimacy to that claim of their illegitimacy as a court? And taking into consideration, and I want to be fair about all of this, I'm going to try to be very objective. We all have biases. We all have opinions. I'm no exception to that. But I think our inquiry today needs to try to be as objective as we can make it. So I'm going to have a list of criteria or things, considerations that you'll see on one of the slides when we get to that. of things that we as attorneys, and I think also I can safely say legal scholars and jurists, would look at to say, is a court really being true to some of the principles of jurisprudence, like precedents, things like that. We'll talk about more of that. And we'll talk about whether the Roberts Court, which admittedly right now, and I don't think there's any dispute in this, admittedly right now the Roberts Court, the majority are political conservatives. The minority now are liberal politically. But going a step beyond that, is there a difference between being politically conservative and judicially conservative versus judicially activist? So I want to talk about some of those issues, but first I want to lay a little groundwork in First Amendment, very small part of First Amendment, very tiny part. You'll get not even quite a sampler platter of just the religion part today. But you see it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. I just want to stop there because we don't have enough time to get beyond that, and we're barely going to scratch that. But what I want to impress upon all of you is that when we talk about separation of church and state, this is where it comes from. In fact, those were Jefferson's words, a wall of separation between church and state. So, and when it says Congress shall make no law respecting an establishment, it doesn't just say Congress shall make no law establishing a church, like the Church of England has, in Great Britain. It uses much broader language, which has been interpreted traditionally to mean anything the government does that tends to promote or endorse religion, as opposed to just letting people have their free exercise of religion. That's the freedom of religion part. So the two sometimes seem like they're in conflict with each other or a bit of tension between the two at times. But in fact, there's kind of a symbiotic relationship between the two. So if you don't keep the government out of religion and keep a separation between church and state, it's very easy to get to a point where you don't have your freedom of religion anymore. Or alternatively, if you give too much on the side of accommodation of religion, you start slipping down a certain slope toward more like a theocracy and less like a democracy. So it's important to keep a balance there between the free exercise or freedom of religion part and the Establishment Clause part. Now, I just want to talk real briefly, and we're going to gallop through this so we can get to the part about the court. But this, excuse me one second. Thank you. The articulated test in Lemon versus Kurtzman, you see the three parts there. And it was a pretty straightforward test, pretty easy to understand and pretty easy to apply. So when a case would come before the court saying, well, the Lemon versus Kurtzman case, just to give you a real quick snapshot, it basically involved secular education in parochial schools. So the cases that come before the court in the Establishment Clause area, non-establishment, whatever, the separation of church and state, tends to be their cases where you're taking public financing and funneling it to a private religious organization of some type. Could be a school, could be a church. Or it tends to be public displays of religion in some way, like endorsement of religion. If you go to the courthouse and you walk in the door and the first thing you see, is the cross and the 10 Commandments, you might say, well, gee, I've come here to do my business, and if I'm a Christian, I'm going to get treated better than if I'm a Muslim or a Hindu or whatever. So that would be an example of public displays of religion in the government sphere or public sector that would raise questions and probably result in lawsuits that may or may not make it to the Supreme Court. While I think about it, that's a point I wanted to make also, which is, you know, when people say, I'll take my case all the way to the Supreme Court, it's like, good luck, you know, because, you know, they get about 8,000 of those kind of requests a year, and they actually hear and decide about 70 cases. So that's less than a 1% chance that your case will be heard before the Supreme Court if you try. And yet, a disproportionate number, more First Amendment cases than any Supreme Court in history, are being accepted now by the Roberts Court. So that's one of the reasons we're talking about a little bit about the First Amendment. So in the Lemon versus Kurtzman case, let's go back for 1 second. Because it involved public money for secular education in a parochial school, the court took the case, the court found that it was a violation of the Establishment Clause in the Constitution because the court said it would create excessive entanglement of government and religion. So, for example, if you're only paying for secular education and not any religious instruction, the government might have to come now and then and audit or monitor the books of the church or the church school. The government might have to send monitors in sometimes into the classroom to make sure that the teacher is only teaching secular things. And so the court said, no, we don't like that. Too much involvement between government and religion. So they struck it down. This was the test for decades. Scalia got on the court. He hated Lemon versus Kurtzman. I'm just going to tell you. He referred to it sometimes as the ghoul in the night that haunts our, you know, gives us nightmares or something, to which one of the other justices reminded him that as scary as Lemon versus Kurtzman might seem, it is still the law of the land. And Clarence Thomas got on the court, and then he kept talking about how much he hated Lemon versus Kurtzman and wanted it gone, wanted it overruled. Well, they did successfully just do that in the coach on the 50-yard line case. That's Kennedy versus Bremerton. And I would love to talk about that case for a long time, but we don't have the time today. But ask me a question about it if you want. But in Kennedy versus Bremerton, the court did officially overrule Lemon versus Kurtzman and kind of got rid of that whole test. So these are some other, and I'm not going to go through every one of them, but you can kind of read some of the other tests and considerations that the court has taken into consideration. I have to kind of look, I have to look down a little bit here too. Oh, okay, sorry. There it is. All right, good. I can see that better. All right, and most of these tests now are kind of obsolete. I mean, accommodation, the court allows a great deal more accommodation now. Endorsing religion, they said we're not so much worried about endorsement. And funding of religious organizations, I think we all know that in the last 10 or 20 years, that has increased dramatically because we have a lot of programs now in a lot of different states, like voucher programs, scholarship programs, tax credits, and so on, that result in more and more financing of church schools. So that is just a fact. I mean, you could think it's a good thing or a bad thing, but I'm just saying that that is, in fact, what's happening. I'm having a little trouble here seeing the screen sideways, so I'm going to follow along here. And I should mention also, and I'm sorry, I'm a little disjointed, but I'm trying to get through this really quickly. But when it said Congress shall make no law, you have to trust me on this. That's more than just Congress. That's more than just the federal government. Applies to state governments, local governments. That's the 14th Amendment Incorporation Clause. So I won't go into that, but trust me on that one. So any government action or government policy by any level of government that tends to endorse or establish religion, whatever that means, and it means whatever at least 5 people in black robes say it means, right? And I also want to make clear that anything I say here today, please don't take it as any hostility on my part to religion. It truly is not. I am a big believer in the Establishment Clause and separation of church and state, but I am an equally big believer in your right to practice whatever religion you want and to choose your own religion and not have the state tell you what your religious beliefs should be. So on the free exercise side of the coin here, our balancing act, I'll tell you what the most movement that the court has made in the last 10 or 20 years, and I'll preface it by saying the belief is an absolute right. The cases that go to the court have more to do with conduct, like where your religion tells you you must do something and the government's telling you you can't do it. If you smoke peyote during your religious exercise or your religious ceremony, as some Native American tribes do, but your state you live in makes that a criminal act, then you have a problem, right? Now you have a conflict. So those are the kinds of cases that tend to go to the court. It has to do with conduct in either performing your religious exercises or you're being told by the state you should do something that violates your religious principles. So, for example, Jehovah's Witnesses, it's against their religion to pledge allegiance to the flag. So that was one of the first cases that went to the Supreme Court. Not the very first, but one of the early ones. And the court said, yeah, just exempt them out. That's okay, and it should be, right? But then when the Amish asked to be exempted from Social Security taxes because they said we take care of our elderly people, the court said, no, not so much. That's a law of general applicability, and the fact that, you don't think you should have to comply. And even Scalia and Clarence Thomas were saying things like, incidental burdens on your religious beliefs have to be tolerated because we have a government that does things for the common good. And they sometimes would use things like vaccinations, mandatory immunizations as examples of one of those. Not so much now. Now the exemptions are very liberally applied. And I guess the most extreme example of that, I don't know if it's the most extreme, but the one that comes to my mind started with Hobby Lobby. And Hobby Lobby, the court not only said the owners, if the owners have religious objections to contraception, you can impute that to the corporation itself, which has religious rights, and it would be against the corporation's religion as well. And then you extrapolate even a little further than that. If you employ thousands of people and the Affordable Care Act requires you to cover preventive care, and preventive care is understood by federal agencies interpreting the parameters of the Affordable Care Act as including contraception, including HIV immunizations, HPV immunizations, counseling on sexually transmitted diseases, and so on. But the court in Hobby Lobby said if the owner has a religious objection, the corporation has that religious right, and they can then exempt out of the mandatory coverage for contraception under the Affordable Care Act for all of the employees, no matter what the religious beliefs of the employees. So you've now gone from an individual right under the freedom of religion to what became a corporate right, to what really became an extension of foisting your religious beliefs on your entire employee population. So not surprisingly, the cases are going up right now, and I heard on the news this morning, which I haven't seen yet, but I heard from Alice, I think, that the court has stayed, perhaps, that case. So I'm not up to date on that, but I know that those cases were working their way through the system up to the Supreme Court, where corporations were asking to be exempted from the coverage for HPV and HIV and so on because homosexuality is against their religion, and if they actually immunize somebody for HIV, HIV, of course, prevents, AIDS, and people were dying of AIDS. So if you actually exempt people, if you actually immunize them for HIV, they might be more tempted to engage in homosexual activity. Or if you immunize them for HPV, which is human papillomavirus, which can lead to cervical cancer, they might be more likely to be sexually promiscuous. Or if you counsel them about sexually transmitted diseases, they might become more sexually promiscuous. So they're asking for exemptions from all of these different kinds of preventive care. We'll see where that goes. Oops, family photo. I know you. Give me a chance to get a drink. Y'all like pictures. Here's our family photo. So as I said, and there's, we don't have to talk too much about this, but you can see Clarence Thomas has the most seniority. And he's asking questions now, finally. So he found his voice. And Ketanji Brown Jackson is, of course, the newest member, so we don't have a whole lot of data on what to expect. But what we kind of do know is this court tends now, not just this court, but maybe for the last 30 or 40 years. No, I wouldn't say that, actually, because there are a lot of justices we've had in the last 30 or 40 years that wouldn't have necessarily voted along the same lines as the party that appointed or nominated them. But now I think you have a court where you can safely say, the party that nominated that particular justice will indicate to you which political camp they're in. I just think that's a true statement. I'm sorry. We can predict their vote a lot more easily now based on that. Unlike the Warren Court, for example, which I do like to kind of compare this court to because, I told you we may ask some questions about, is the court just getting a bad rap right now for no apparent reason, other than some people are disgruntled that they're not getting the decisions that they want, or, the fact that we question the legitimacy of every aspect of government right now. Congress's ratings are down. People don't have confidence in Congress or in the presidency. But the court used to get about 50% of the people that had confidence in the court. Now it's down to 20 or 25, which is still higher than Congress or the president. So, and the press, the free press. We don't have confidence in the news or the journalists anymore. We're kind of a skeptical people right now. So I ask myself how much of it is not really anything to do with the court and what it's doing, or is it doing some things that are making people feel uncomfortable? And if so, why? So getting to political conservatism versus judicial conservatism, are they the same thing? And they're really not. Political conservatism, you can define it however you want. I think we all have a sense of what that means. But judicial conservatism versus judicial activism, I think is easier to quantify and to define. And here are some of the considerations that we would look at if we were trying to decide whether a court is judicially conservative or is it pretty activist. I think the number one everybody would agree on is respect for precedent, stare decisis. In other words, the doctrine that if your same Supreme Court had this same or very similar issue in the past and you have a Supreme Court decision on it, and particularly if it's a Supreme Court decision upholding the constitutionality of number 2, a democratically elected statute, then you would strain to not overturn either of those things. If you have to, and the court loves to use Brown versus Board of Education as the poster child for this. So let's talk about Brown v. Board of Education, and let's compare it to, let's say, Dobbs. All right, in Brown versus Board of Education, of course, Plessy versus Ferguson was overruled, and Plessy went back more than 50 years. And, aside from the issue in the case, which I think we all now would agree it needed to be overruled, but at the time it was pretty controversial. But in Brown versus Board of Education, you had a 9-0 decision, and it was 11 pages long. I know, isn't that shocking? Do we do that? Do we ever see that anymore, ever? So compare that with Dobbs, which is over 200 pages long, and there are 5 decisions, 4 of them on the majority side. So even the majority of the 5 who decided to overrule Roe v. Wade and Dobbs couldn't decide on the rationale. They each had to each one wrote their own opinion. Now, Roberts, I understand why he wrote his own opinion, because Roberts actually was being a little judicially conservative in Dobbs. He wrote his own opinion because he didn't agree to overruling Roe v. Wade. He agreed with the result that you could uphold the statute from Mississippi, wasn't it? Yeah, Mississippi, that banned abortion after 15 weeks. He felt you could get to that result without completely overruling Roe. And the other 4 justices didn't agree to that. They explicitly wanted it overruled. And on page, I think it's 79, I'm pretty sure, of Alito's opinion, they specifically say Roe v. Wade is overruled. So, but why the other ones had to write separate opinions? Can we flip to number 4? Not communicating from the bench, the types of cases the court wants to see next. Clarence Thomas writes a lot of separate opinions. He writes them some of them are so extreme that nobody else will sign on to his opinions. But he writes separate opinions a lot of times also because he communicates to people. What's the next case we'd really like to see? What do we want you to bring? So he did that, and remember in Dobbs, I mean, he did that. He said, boy, now that there's no right to privacy in the Constitution anymore, we probably should take another look at Griswold versus Connecticut, the contraception case. Because if you don't have a right to privacy, the state could maybe ban your, birth control pills. And maybe we better take another look at Obergefell, which is the same-sex marriage case, right? Because that's based on a right to privacy. He didn't mention Loving versus Virginia, even though that did invoke the right to privacy also. But that kind of communicating from the bench, bring us this case, now bring us this case, is not a judicially conservative thing to do, in my humble opinion. The court would, if you're a conservative court, you do everything possible to avoid legislating from the bench. I would be a little bit critical of the Roe v. Wade decision for that very thing, because I think that they actually did go into a whole lot of details that we might say is more like legislation than jurisprudence. But there's a whole lot of that going on right now, too, in a whole lot of cases. Whenever possible, try to arrive at decisions with either a unified court or vast majority. All right, we kind of talked about that, the Brown versus Board of Education and Dobbs. And it's not just Dobbs. Almost every decision now, there's 2, 3, 4, 5, 6 opinions, There's rarely even just one majority opinion and one dissenting opinion. The dissenting opinion is usually just one. I should be giving you more examples of cases because there are so many, but I'm just trying to make sure we get through the stuff we should. So at least considering the effect of a decision on the country, like on our social order, political and legal ramifications, and so on. I'm going to give a shout out, as people say, to Sandra Day O'Connor. And actually, quite a few people, Souter was another one. There are a lot of conservative jurists who were appointed by Republican presidents who turned out to be more moderate, much to the chagrin of some of the people who appointed them. but turned out to be more moderate and turned out to be, as Sandra Day O'Connor was, a lot more, I think, cognizant of when the court does major things like this, it affects an entire country of people. She really had a good sense of that. I don't know if the court considered that in Dobbs or not, but you can see we really are still trying to straighten out the mess, aren't we? And we might be for quite some time. Showing consistency across cases in philosophy and statements of legal principles, like states' rights. If you really say we're really big on states' rights, please tell me how you got to Bush v. Gore. And I can't blame Roberts for that. That was before him. And Justice Souter, who was appointed, of course, by George W. Bush and who was considered a conservative jurist, Justice Souter almost resigned that night that Bush v. Gore was decided. In fact, he was purportedly found sometimes to be weeping openly about Bush v. Gore. He was very, very, very upset about it. But if you really believe in states' rights, and you can go to the Constitution and look at language that gives the state the right to fashion its own election procedures within the ambit of the Constitution, and recount of your votes is certainly within that. And the Supreme Court of Florida said, we'll recount the votes that are requested for a recount. How do you get to that result if you're a big proponent of states' rights? So be consistent. That's all I ask. And then the tests that you apply, if you keep shifting that test to get to the outcome that you want to get to. Like right now, the favorite is history and tradition test. So that was used in the Dobbs case, that was used in the Coach Kennedy on the 50-yard line case, and that was used in the Bruin case that struck down New York's some gun regulations in New York, which again, you would think there would be a little bit of deference to states' rights. So history and tradition, it's not my personal favorite, because I think it's the one that's the easiest one to cherry pick. You know, you just go to whatever, and I see my good friend Tom back here, who's a very good student of history, and Tom could tell you anything you want to know about history and where you can pick from if you want to get to a certain outcome. We've had discussions on that. So, you know, that's some of the stuff that, okay, so let's get to number 9, because I know that's what you all are most interested in. Avoiding even the appearance. This is what a judicially conservative court would do. Try to avoid even the appearance of having the outcome of a case affected by the political, religious, or philosophical biases of the individual justices. Now, I'm going to cut everybody a little slack on that, because I think we all are a package of attitudes, religious training, you know, family background, whatever. When we come into adulthood, we're kind of packaged into a certain, you know, mindset that's really hard to lose sometimes. We have biases based on that, explicit or implicit. And I think the important thing is to recognize when you have biases and factor it into your equation, factor it into your consideration of a case or of anything in life, of your opinions or discussions with people or whatever. But try not to let that be the deciding factor in if you're a Supreme Court justice, in the disposition of the case. B, avoid even the appearance of having the outcome affected by conflicts of interest for which a justice should have recused himself or herself, or affected by pecuniary gifts, donations, hospitality, quote unquote, compensation. See, I know that's why you're all here, right? Speaking engagements and so on from donors. So when, you know, I'll let you be the judge of whether Justice Alito is right and they're being unfairly picked on, or whether you really do think we have some issues, and whether this court is judicially conservative, whether it's judicially activist. I'll let you be the judge of that. But I've just tried to put down some things that I think most of us who are involved in law would look at to try to gauge those things. And I am concerned about some of the directions that we're going right now in law, in First Amendment jurisprudence particularly. But that's my pet peeve, but they really are taking more First Amendment cases than any court in history. So I don't think that's just me. I think we have another slide or two there. Yeah. Is the Roberts Court, I mean, some people would say, well, people said all this about the Warren Court. How is this any different? You know, if you like the results of the Warren Court, but you don't like what you're seeing from the Roberts Court, isn't that just your own personal preference? I guess what I would say, and part of what I already did say, which is the Warren Court. Number one, on the Warren Court, you had what were perceived to be politically conservative or politically liberal jurists, both. I mean, everything from Thurgood Marshall to, you know, Warren himself and Souter and a lot of other, well, Souter wasn't on the Warren Court, sorry about that, but I'm using him as an example. But on the Warren Court, I don't remember who all was on that court and who all was appointed by whom, but I know that it didn't break down along partisan lines. And so that tends to make their decisions a little more defensible, palatable, whatever, to the public. But they were deciding cases during a time when this country was really quite racked with civil rights issues, demonstrations, you know, I mean, things that had been festering for a long time and that were coming to a head. And Congress, of course, remember, was passing a great deal of civil rights legislation under LBJ during this same period of time. So the Supreme Court decisions kind of reflect what the times were doing and what the Warren Court tended to do more than just take off in a different direction was take things that were already civil rights under the first 10 amendments, or up to the 14th even, and put flesh on the bones. That's how I'm going to put it. Now, maybe again, could be my bias, I don't know. But when I looked at some of the key cases coming out of the Warren Court, like Miranda versus Arizona, Gideon versus Wainwright, Loving versus Virginia, so on and so forth. I mean, there were a number of cases. And basically what Warren himself, who had been a former prosecutor in California, he was very sensitive to the issue that a lot of criminal defendants, while they have certain rights that are in the Constitution, they were not getting any chance to exercise those rights because, number one, they didn't even know that they had that right. Number two, they didn't have any legal representation. Number three, they were sometimes victims of illegal searches and seizures and then police questioning that basically may or may not have always been fair. So he was pretty sensitive to those issues. So what he was concerned with was putting some safeguards in place that would make sure that those rights that you have in the first 10 amendments actually are ones that are meaningful. And I think that's different than suddenly, I don't know, I mean, I'm just going to say this, and this may sound, my opinion, political, whatever, but ripping out a right that we thought we had for 50 years that affects 51% of the population, and saying there's no right to privacy. No right to privacy. And I have zero problem getting to a right to privacy in the Constitution. I don't think that's even an issue. I mean, if we don't have a right to privacy, we really don't have any rights, do we? And so, you know, you look at the 1st, the 4th, the 5th, the 9th, the 14th, and illegal searches and seizures. What is that based on besides the right to privacy? The constable can't come and break down your door, come in your house, seize evidence of whatever alleged crime, and then charge you with a crime without probable cause, without a search warrant, without safeguards in place. Why is that? Because in your home you have a right to privacy. You know, First Amendment, your freedom of religion, is based really on your right to privacy. 14th Amendment, due process, liberty, equal protection, the Ninth Amendment says, just because we didn't enumerate everything in the Constitution doesn't mean you don't still have it. You still have your natural rights, your fundamental rights. So I don't have any problem finding a right to privacy. I certainly, I don't want that to be construed as, I think everybody should just have a right to have an abortion for as long or, under whatever circumstances they want. But to say you have no right to privacy is a big, big leap. How am I doing on time? Am I really? Oh my God, I could have said a lot more. Okay. Well, let me just look and see if there were, there are cases. I said I would love to talk about certain cases if we had more time. But, I'm willing to open it up to questions, and then people can, I'll see what people are interested in, and maybe I'll try to help you with it. I'm not an expert on everything, and I don't know everything about everything, but I'll try to help you.
But you're doing a wonderful job.
I'm exhausted. No, just kidding. It's a marathon. Oh.
Jean Howard is going to be handling our questions, and we will have a microphone. If you want to put your questions on a card, if you'd rather bring your question out that way, or we could bring a microphone around to you. How's that?
Is this on?
No, I mean to who has a
Oh,
question.
to them. Oh, sure, yeah. I was going to say, I have a mic.
Will you introduce yourself, please?
I'm Vic Landa, and I'm currently a student at NMC, and I took Eleanor's class on the First Amendment, but I was going to ask Eleanor if she would expand a little bit on the Citizens United case, because I think that's a real critical one. I know it'll keep us here all afternoon, but...
No, I knew. I was like, there's probably a big case I should have been talking about that I just, because I'm not looking at my notes at all. But yes, it's like the poster child for judicial activism, and thank you for jogging. See, he learned a lot in that class. That's because I probably talked about Citizens United for 45 minutes, I think. And I talked about Coach Kennedy for 45 minutes. But yeah, Citizens United, there's more to that story even than I think most of the public knows. And the more you know about it, the more egregious it is in terms of judicial activism. So remember when I said a case should be decided as narrowly as it can be decided, right? And remember when I said you don't overrule precedent and you don't and strike down statutes and everything unless you absolutely have to, right? Well, in Citizens United, putting aside the fact that they found corporations have the same First Amendment rights that you and I have, that's not only free speech, that's religion now, too, because of Hobby Lobby and that whole progeny of cases. And putting aside that, it kind of opened the door for a lot of contributions, shall we say, into campaigns and into the political process, some of which is very difficult to trace where it came from. But what's interesting also about Citizens United is, for those of you who don't recall exactly the facts of Citizens United, it was you remember there was about an hour and a half, what should I call it, a docudrama? I don't know what, a video about Hillary Clinton. Remember that? And it was shown in a few theaters, and it was shown, I don't know where all, but Citizens United was the politically conservative lobbying group, whatever, that made that film and wanted to promote that film. And they wanted permission to show that film on video on demand within 30 days of the election for the primary. And the McCain-Feingold Act, which, hold your breath here, was a bipartisan statute. We don't see that anymore either, do we? So it was a bipartisan statute where Republicans and Democrats agreed that campaign restraints campaign financing restraints were necessary to avoid introducing more corruption into the political process. So the McCain-Feingold Act prohibited showing TV ads of a certain type that were funded by corporations or unions within 30 days of an election. I'm pretty sure I got that exactly right, but please don't totally trust my memory on that. So Citizens United came into court asking for a very narrow ruling. And it was argued by Ted Olson. I don't know if you remember, Ted Olson was the same attorney who argued Bush v. Gore. And unfortunately, I'm pretty sure it was Ted Olson whose wife died, I think in Pennsylvania in that plane crash. Anyway, Ted Olson was the attorney arguing for Citizens United. And he felt his best way to win the case was to keep it very, very narrow. We just want a ruling that we fall within an exception to that McCain-Feingold prohibition on showing TV ads within 30 days, because this really isn't a TV ad, and we're not showing it on TV, we want to show it on VOD. And that's all we want. And the parties stipulated that was the narrow issue going to the court. And that's all we need the court to decide. Couldn't be clearer than that, folks. I mean, in my experience in practicing law, you hardly ever even see that kind of unity between the parties. So it came before the Supreme Court, and Justice Roberts, who of course is the Chief Justice, so he gets to decide who writes the majority opinion. 5 of them wanted to rule in favor of Citizens United. 4 did not. You can guess the breakdown. And Roberts said, well, I'm Chief Justice. I get to decide. I'll write the opinion. So Justice Roberts started writing the opinion very narrowly. He wrote his opinion only granting that relief asked for by Citizens United, that they were not subject to any fines under McCain-Feingold, which had been upheld in a couple of cases also, including our Michigan case, Austin versus State of Michigan, or whatever it was called. I have it here somewhere. So Justice Roberts was going to actually be judicially conservative, keep it narrow, only the relief they're asking for. Don't overrule a bunch of stuff. Don't strike down a bunch of statutes. And Kennedy wrote a separate concurring opinion, gutting everything. You know, while we're at it, let's just get rid of McCain-Feingold. Let's get rid of this, case or two that's upheld it. Let's get rid of this other thing. And Justice Roberts, I think at first wasn't totally convinced that they should do that, but he did get moved over to that. And that was when he was fairly, not real new on the court, but fairly new compared to now. So he agreed he would go into that decision that Kennedy wrote, and they'd have a majority of 5 in one decision. Justice Souter, who was still on the court at that time but was close to retirement, was outraged by what the court was trying to do. And he wrote a scathing dissent from what I have read and understand. I haven't seen that dissent because it never saw the light of day. But he wrote a scathing dissent that some of the other justices took great offense to because they don't like that. And so they said, what to do? Okay, we got it. Let's set it for a rehearing, and we'll set the rehearing date for September whatever it was, which was like 3 or 4 months later. And that would have been after Justice Souter's retirement. Now that's bad enough. It gets worse. Sorry. My allergies. Excuse me. 1 second. Thank you. I thought I might lose my voice today. You're all relieved, right? Anyway, so Justice Souter had retired in the meantime, but they not only set it for a rehearing, they ordered the parties to brief the issues of whether they should revisit McCain-Feingold and the cases that had upheld it, whether they should just look at all of that while they're at it, and the constitutionality of whether you can put these kind of caps on, you know, contributions, political speech. And so, you know, Ted Olson's no dummy. I mean, he's won a lot of cases. He saw the handwriting on the wall. He came back in prepared to argue that, and that's what happened. The rest is history. But, wow, I mean, when you know that whole story, it makes that case, yeah, thank you, Vic. Anybody else wanted any comments, whatever?
My name's Gretchen Krunk. Vic, thank you for your question, because I'd been thinking about the decision, the Hobby Lobby decision, and would that have happened, would it have gone in that direction had Citizens United not preceded it? And you just answered that question. So what's been bothering me since it was mentioned is, I think it was Alito and Thomas just despised the Lemon decision. For what reasons? Can you give a little anecdote there?
Yeah, well, okay, I don't know if you wanted to ask about Hobby Lobby or the Lemon versus Kurtzman test, because I don't necessarily see those as the very same thing, but I can tell you in Hobby Lobby, the groundwork was being laid for corporations having First Amendment rights, especially speech and contributions and so on, a lot, way before even Citizens United. I think you could go all the way back to the Powell memo in the 1970s, and then Powell was on the Supreme Court, and a couple of cases that he wrote opinions on, he was making a lot of those same noises, and then in Citizens United, they took that one step further and just made it law. And Hobby Lobby, yes, the fact that the corporation has First Amendment rights and so on, I think did come from Citizens United. Is that your question, or do I understand
No,
it?
I apologize. It was a poor segue on my part.
All right,
My
I'm sorry.
original question would have been the two justices who despised the Lemon decision.
Mm-hmm. Scalia and Thomas.
Thank you, Scalia,
Mm-hmm.
Alito, and Thomas. Why?
Why did they hate it so much? That I asked myself. That's a great question, because I told you, I look at that Lemon test and I think it's pretty straightforward. I think it makes sense. I think it's easy to apply. And if you were to say wall of separation between church and state, I think those are the three things you would really want to take into consideration. Now, you know, I don't want to ascribe any motives to them. If they just simply wanted to see, you know, more religion in the public forum and in public schools and whatever, and maybe they wanted to get to that point, or certainly more public funding of parochial or sectarian schools. I know they wanted to get to that. And, you know, I think I mentioned up here Aguilar versus Agostini, which is another egregious example of something we never do in law. And there's a doctrine called res judicata, and that means if if the same parties have already had their day in court and they've appealed as far as they can appeal, and you have a final decision as to that case and controversy and those facts and those parties, they're done. They're done. You don't get to come back and say, I didn't like the result we had. Let me try again. But what happened in this 12-year period between 1985 and 1987, that case involved public funding of schools. I think sectarian instruction again, secular instruction, if I remember right. And it was actually coordinated with the Ball versus Grand Rapids case here out of Michigan, which was the very same, they were kind of consolidated even, or at least came up at the same time. And in the first decision in 1985, the court said, no, it's a violation of the Establishment Clause. 12 years later, the court took the case, the very, very same case again, and decided exactly the opposite way. Now you said, what happened in between? Nothing happened except a change in the composition of the court. Clarence Thomas came on, Scalia came on, and three or four other people. They definitely had a majority at that point to do it. And that's the only difference. And that violates what we call res judicata in a big, big, big way. And I've never seen the Supreme Court do that before. Maybe they have, maybe I just don't remember it. But I don't remember ever seeing that happen before. And I can't blame Roberts for that. That's before the Roberts Court. I don't even blame Roberts for any of this except Citizens United. Because Roberts really is the most judicially conservative on that side of the court.
Okay, we have another question here.
Okay?
Hi, my name is Ann Sweeney.
Hi, Ann.
Hi. This is something I haven't thought about for over 50 years, and your discussion of the Warren Court suddenly brought to mind of picturing a young couple from Michigan moving down to Texas to live for a few years in the late 60s. And it's probably within 5 or 10 minutes after we crossed the border into Texas, here's this giant, giant billboard saying, "Impeach Earl Warren."
Oh, yeah.
And
He
it
got
was-
death threats.
And it just, and we thought, oh, what are we moving into?
Yeah.
You know,
Yeah. Alito was really upset that some of the Supreme Court justices had death threats after the leak of the Dobbs decision, which I don't condone at all. I don't think it should ever, ever happen. But he made it sound like this is a new thing. And I mean, Warren definitely had death threats.
also have a real question. And that is, I've been hearing a lot recently about the shadow court, and I don't know if you.
The shadow docket.
The shadow docket. And could you talk about that just for a few minutes?
Yeah, it's kind of shadowy to me, too. And you even have now Alito and people like that complaining about the shadow docket, but they're all a part of it. I mean, the people complaining about it seem to me like the people that have been engaging in it the most. And from what I mean, it's just like when somebody comes to the Supreme Court, and if it's like supposed to, well, I don't know for sure. Honestly, I'd really want to research this because it's vague to me too. But I think that even just one justice could accept a case that's like an emergency case, and then it has to go to 4, and then of course you need a majority of 5 to have a decision. And sometimes these things kind of get brought to one person or whatever in the middle of the night is, kind of the suggestion here, but it's obviously not usually in the middle of the night. And it can really expedite a process of getting something done. But usually for something like that, you have to show substantial likelihood of success on the merits, and you have to show that there will be irreparable harm if you don't get immediate relief, like a stay or something, So I would want to look at that more closely because I really don't fully understand when they keep talking about the shadow docket, what all goes into that mix either. Yeah, like I said, it's a mystery to me because I think the very people that, to me, have kind of engaged in that sort of behavior seem to be the ones complaining about it now, and they're the ones with all the control on the court. So that's what I don't get. I think there has to be more to the story, and I don't think I know what it is. So I'm going to dodge that a little bit. Yeah.
There's a question here that was on a card, and it's talking about the ethics of the court, in particular Justice Thomas. How will the Supreme Court handle him, or will they just ignore all these information that's come out about his gifts, et cetera?
Yeah, that's a good question. And I can't tell you, number one, while Justice Thomas seems to be the most egregious offender at the moment and the one that reported the least, he's not the only justice that has accepted gifts or free trips or whatever. That's unfortunately a problem across both sides of the aisle here. I'm not even saying one side's worse than the other. With Clarence Thomas, the failure to report anything ever for years and even to misrepresent sometimes, his wife's income and all kinds of things goes beyond the pale. But there's too much of that going on across all of it. But what does seem to be happening right now, I don't know if anything will really come of it, but there is a bill in the Senate and there's a bill in the House of Representatives right now. The one in the House of Representatives, I only had a chance to look at it real quickly. But it does seem to provide a lot of proposed amendments to Title 28, USC 28, Section whatever, 360, whatever, which is the part of the federal statutes that provides reporting requirements and ethics procedures and so on and so forth for federal judges, but the Supreme Court justices were not previously a part of that. Mostly they were left. They had a few reporting requirements because of a 1979 statute, I think it was. But they weren't part of that whole 28 USC, section of the code that basically regulates judicial conduct. And so the proposed amendments look like they're adding the word justice and Supreme Court and so on to all of those requirements. And Congress and as well as the court administrative staff and the Supreme Court itself, which is supposed to create, according to this proposed bill at least, if I remember right, the Supreme Court would institute some procedures for accepting complaints, reporting those complaints back to the court administrative. It's got a whole administrative, and it also includes requirements for parties coming into the court, including amicus parties, which is good because there are a lot of amicus parties now, a lot, every case. And so they have reporting requirements now also, where they're supposed to, if this goes through, then they're supposed to report whether they or their corporation or their family members or anybody has donated any money to, or assisted in getting somebody nominated to the bench or whatever. I mean, it's a whole long list of things. But it does look like there's movement on that front at least, and that's good.
We have another question here.
And impeachment, I guess I should say also, in terms of Justice Thomas. I mean, if you wanted him off the bench, I think impeachment is the only avenue, and you do it through the regular impeachment procedures that would look the same as if you're trying to impeach a president.
Hi, I'm Tom Gutowski, and my question is, how would those, if Congress does pass laws imposing a code of ethics on the Supreme Court, how would they be enforced? And would there be any constitutional constraint on the ability of one branch of Congress to legislate what actually happens to people in the other branch if they violate the law?
Yeah, I mean, it's very vague in the Constitution, but Article 3, which of course is the article that sets up the Supreme Court and the lower courts and so on, does give assign some responsibility to Congress to basically regulate. It uses the words good behavior even. You're on the court for life, but Congress may assess good behavior, whatever, blah, blah, blah. And if you want them off the court, you have to impeach them. But it does, and of course Congress has power to set up the lower courts and everything, which is why you had all these Title 28 provisions that basically regulated the lower courts. So there is some congressional authority over that. I think it's safe in my mind to say you would kind of need the Supreme Court to feel comfortable that they're collaborating on it and that they're involved in it, because as the last word, I mean, they could strike down your statute as unconstitutional, right? And then you might have this, separation of powers thing that might turn kind of ugly. So, yeah, it's a good question. I don't think there's an easy answer to it, but Congress does have at least some authority over the Supreme Court and their good behavior and so on. Putting the flesh on those bones, I'm not sure what all it would involve or, what would sustain and not.
So I'm Alice Schumann, and in continuation of what you just said, does the Constitution say that the Supreme Court justices are for life, or is that something that the Congress could change?
It doesn't use the words for life. And I told you, I never leave home without it. Article 3 of the Constitution uses the words, get to it real quick. I think it's, got too many, see? Okay, there's Article 2, here's Article 3. The judicial power of the United States shall be vested in one Supreme Court and in each inferior courts, as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services compensation and so on. So, you know, as long as they're not impeached, that's how, in my legal recollection and professional judgment, as far as I know, that's how it's always been interpreted. Well, yeah, exactly. You know, for the president, we could say that too, right? I mean, impeachment's not an easy road, you know. Vic,
Vic Landa again, asking a question about the Kennedy versus Bremerton School District. At your urging from class, I read Sotomayor's dissent.
all 30 pages, huh?
Yes, all 30 pages.
Didn't it sound like a totally different case than the
Yes.
majority?
And so, as you know, in class, I sided with the side that said that the Supreme Court had gotten it right. But having
'Cause
read
you only
that,
read that
I
little
don't believe it
appendix.
anymore.
You don't believe it.
He laid out a very good case that they got it wrong. So maybe you can just give us a little bit more.
Oh, the Reader's Digest version. All right, you all remember this from the news, right? Coach Kennedy, who really felt his religious, oh, you don't remember that? Because it was on the news at the time, kind of off and on and everything, and he was making quite a public spectacle for somebody who was having his own little personal private prayer in his personal time. It certainly was very public. But anyway, he claimed that his religious convictions, he was the coach, okay, at a high school. And it's a public school. And I will just tell you, and you'll have to trust me on this, before Kennedy versus Bremerton School District, I think the case law on this particular issue of school-sponsored, school-led, school-endorsed prayer led by officials who are in a position of authority over students was universally considered a violation of the Establishment Clause. That when you send your child to public school, you shouldn't have to worry about whether the teacher's going to try to educate them about or indoctrinate them or whatever with their own religion. So prayers in the public schools, once you get to the university level, totally different ball game or football game, whatever. But in K through 12 setting, it was all the way back to Engel versus Vitale, and pretty consistently, I think always consistently in my recollection, the court has said no school-led prayer or religious exercises in a public school. So not by the teacher, not by the principal, not by the coach who's a role model, etc. So the only way that the court, and Coach Kennedy said, my religious convictions require me to go out on the field right after every football game, win, lose, or draw, and say a prayer on the 50-yard line while the spectators are still there, while the players are still in the field, everything. And so the players kind of started, you know, he was doing this, and he was vocal in his prayer. He wasn't, you know. And all the players kind of started, you know, and he said, well, you can join me if you want. And so pretty soon all the players were on bended knee all around him in a big circle. And he would take one of the helmets and hold it up. And he would loudly say his prayer. And all the students, you know. And I'm going to just tell you real quick so I don't forget to tell you, after he got put on administrative leave, the students never prayed on the 50-yard line again. But his defense was, he said, it was voluntary. I never required them to do it. They wanted to do it and so on. And they all said, well, we felt kind of pressured. He is, after all, the coach, and you want to play football, right? So the school district, once they started figuring this out, they told them, you know, here's your policies. It was in your employment contract, you know, and so on. You know you can't lead prayer. You know you can't engage in a school-sponsored activity in encouraging or expecting, you know, your students to participate in your religious exercises. So it really needs to stop. And plus you're still working at that point. You're in charge, you're supervising, you're in charge of the football players, even back in the locker room until you've discharged them to the bus or to their parents. And then if you want to go back out on the 50-yard line, after everybody's gone and so on, and say your prayer, have at it. You know, we encourage it. You're more than welcome to. And he tried that once. He said, yeah, that's just really not working for me. So then he went to the media and everything, and he's, oh, and the district superintendent came, and, you know, to one of the games, and it was an away game, and the superintendent said, you know, you can't do this anymore. We're going to get sued for violating the First Amendment and so on. We're endorsing religion and so on. And so he said, don't do it anymore. And that same game, right after the game, Coach Kennedy, in loud terms, said his prayer and everything. And so then at some point he started saying, well, all right, I don't have to say it maybe quite out loud or say it as loud. Oh, and that night, I forgot to tell you, as they were coming back on the bus, when the superintendent told him not to do it, and he did it, he posted on Facebook, I think I may have just gotten fired for praying. Okay, but he didn't get fired, and they still tried to work with him, and they tried to come to some agreement, some compromise, and he didn't respond to that, and he went to the media instead and said, tomorrow night's homecoming, I'm going to pray on the 50-yard line. So then it became a media circus, and then all the spectators from the stands started storming off the stands down onto the field and everything. They knocked over some of the band players, everything. And then the school district started getting these phone calls from, you know, Satanists. If he gets to pray, we're going to have our prayer, you know, at the next game. And from parents who were complaining, and it just became... And so at some point he was put on administrative leave, so he sued, and the Supreme Court took his case. And the Supreme Court said it was his personal, private prayer done during his personal time. Therefore, it not only was not a violation of the Establishment Clause, it wasn't even an Establishment Clause. It was his free exercise of religion and freedom of speech. And not only could the school district allow it without violating the Establishment Clause, they were required to allow him to do it. So that's a pretty big leap from where we used to be. And I think all I can say is start looking for a whole lot more prayer in the schools cases in the Supreme Court, because that door is cracked more than a little bit now.
Okay.
Now, no yoga. No yoga. That's religious.
Yeah, we have time. We have time for one last question here.
My name is Shelley Smithson. Speaking of school districts, I've just been wondering what might happen in Florida with the state governor trying to impinge certain beliefs and thoughts on the what I consider to be freedom of speech rights of the school districts in choosing educational materials for the welfare of their students. And I wondered if a school district, say school teachers union, raised a case with the state government, could that ultimately find its way to the Supreme Court?
I think a lot of what the state of Florida is trying to do right now, in my opinion, and I have to preface it that way because I'm not on the Supreme Court. You should be lucky. But in my opinion, a lot of what the state of Florida is doing right now violates the First Amendment, both on the free exercise of religion, the Establishment Clause, and free speech. They have violated the First Amendment, even what they did to Disney. You know, when they penalized Disney for political speech, for disagreeing with his policies, that's a violation of the First Amendment. I wouldn't even know where to start. And now they're proposing bills that will require public school districts to set aside so much time per day for prayers and to prominently display the 10 Commandments in every single classroom. So yeah, there's no, I don't know. I don't know if it's just a DeSantis circus or if they really think they can, and if they actually can have all those things upheld, then we are entering, well, we're entering, what did I read this morning? Just this very morning before I left, this Reawaken America tour led by Michael Flynn. This was his comment. He says, if we are going to have one nation under God, which we must, we have to have one religion, one nation under God and one religion under God, right? That's Michael Flynn talking at this conference, at a Trump hotel, too. No, I don't know. No, don't take that in kind of way. Don't blame the League of Women Voters. I'm not telling you how to vote or not vote. It is a fact. Okay, I'm sorry. But yeah, one thing they didn't do was allow Scott McKay and Charlie Ward to attend because they had just posted on this website for this organization in praise of Hitler, that Hitler was actually fighting the same people that we're trying to take down today. So to me, it's kind of some scary stuff going on. I don't know. I'm a big believer in the First Amendment, and, it upsets me a little what's going on. But do you need a microphone? Well, that is a term of art, as far as I'm concerned, and what it means is what you do on the bench judicially in deciding cases, the procedures you follow, and the doctrines that we all accept as being sound jurisprudence should be applied. And if you aren't adhering to those kind of principles and you aren't deciding cases with that methodology and those intentions, then you tend to be called a more judicially activist court. That would be the other side of that coin. And most political conservatives don't like to be called an activist of any sort, but I'm just saying I think there is a difference between political conservatism and being a judicial conservative. And I think that Justice Roberts, other than Citizens United, maybe there are other ones, I haven't read every single opinion on every issue, but of the ones off the top of my head, Citizens United, he wanted to be judicially conservative and then got dragged into something that was anything but. But most of the time, I think he cares about the image that the court projects. He cares about the legitimacy of the court. And he has, from everything I'm reading, he's kind of depressed about the fact that it doesn't have that image and that he hasn't been able to maintain that as the Chief Justice.
Eleanor has graciously said she would stay after. Our timeline is dependent on the wonderful aspect of being in media, so that we need to wrap up by a time. And then, and then we can stay and continue on after we do our final wrap up. Thank you so much. Many thanks. The complexities are overwhelming in understanding it and in looking at everything regarding the Supreme Court and the Constitution and the amendments. So we greatly thank you. And we thank our audience for tuning in today and for our studio audience being here. Thanks to Aaron Olson from Traverse Area District Library, to Matt Kern and Joe Torrance from Traverse Area Community Media. I just had this flash of the Oscars where you get pushed off the stage. Please complete their evaluation forms either on your seat or they will be distributed by League members. To find out more about the League or to join, please visit our website at lwvgta.org for League of Women Voters Grand Traverse Area. And thanks again for being with us. Tell your friends that this program is available for viewing on the Traverse Area District Library YouTube and the League of Women Voters Grand Traverse Area Facebook page, and also on Spectrum Cable TV channel 189 in Northwest Lower Michigan. Thank you.